Hey, this is Gary Berger with another edition of Lawyer v. Lawyer podcast. I have a special guest today, Steve Gerring. Stephen, how are you?
Doing well, Gary. Thanks for having me.
Absolutely. Thanks for coming on our podcast. And, you know, you and I have been friends for a number of years here. Tell all of our listeners a little bit about the type of practice you have.
Well, Gary, I do personal injury law. I've been practicing on my own since 2014. I run a true solo personal injury law firm. I work predominantly from home by choice, and I have done so pre-pandemic and now during the pandemic.
You were pandemic before pandemic was cool or
in
occurred.
A way, yeah. And in a way, I also don't like that everyone is kind of caught up to my competitive advantage in that way and figuring out there's other ways of doing things aside from the traditional brick and mortar setup, especially when it comes to personal injury cases. But it's for the best.
Well, you run a great practice. I've really been impressed with a lot of things you do. One of the things that I've seen you do well is get great resolutions in cases in the claim stage of the case. So I've asked you, I really wanted to talk today, and we could do a whole nother podcast on how you run your practice in different ways. And you've people are catching up to you. But one of the ways I wanted to talk about today is maximizing the value of a case in a claims stage of a case.
Okay.
What's your coming out of the box? Give me a tip on how to do that.
Well, I think it's important when you first get a case in to set up treatment depending on what stage the case is in. You may have to set your client up with treatment, be it at a chiropractor or sending them to an urgent care or to a specialist if need be to evaluate your client's injuries.
Right. So when we get cases, and so do you, at various stages. Sometimes you get a case coming in, the person's done a lot of the treatment. Sometimes I got a call yesterday. I was in a car wreck. What do I do? And I said, go to an urgent care. Do you have a primary care doctor? Go to your doctor. Some people, they know they just can get their care because they have health insurance through their providers. Some people don't have health insurance. People are at different stages. So sometimes when you say get them the medical, I think you're meaning, give them recommendations about the type of medical treatment that may assist them in recovering from their injuries.
That's correct. And it's something you kind of gain experience as the longer you practice, figuring out those things that you mentioned, whether they have health insurance, or they don't have health insurance. If so, are there any options, be it on a lien or otherwise, for them to get treatment without putting an undue financial risk on them. And that's a concern for most people.
I was talking to my client last week. She's a nurse, very, very knowledgeable about the medical. We were talking about settling her case. The case is she's been treating for about 2 years. And I said to her, she says, I'm still having pains. I'm still having all these problems. She's gotten injection stuff. I said, did you ever have an MRI of your neck? And she said, no. And I said, well, listen, I don't want to. My concern is there's something else going on here. And she's like, yeah, I know. And so we were all in agreement. But until I had that conversation, even with a savvy person, a medically trained person who knew the treatment, and we've talked to her a lot, it was just kind of an organic, and I said, I want you to get an MRI before we settle this case. And she said, can I? I said, sure, let's go back to your doctor and her primary care and explain she's still symptomatic, blah, blah, blah. And she did, and she's going to get it. And I don't know what it's going to show. So one of the things that I want to disabuse anybody listening to this is that somehow lawyers are cooking the books or manipulating the medical. The way I'm not trying to speak at you, Steve. This is turning it over for a question. My goal is trying to provide information, help coach, give them advice in a situation where they do not know what to do or how to handle getting medical care. What's your philosophy?
Well, it's certainly educating them if you have the opportunity to do so based on your experience. And you have to keep in mind, sometimes you have clients that don't necessarily want or care to seek medical treatment, and that's kind of based on their personality type. And I know I'm one of them personally, where I don't really like going to the doctor a lot. I don't.
So
want
what do you
to.
do? What do you tell those people?
Well, that's when your experience knowing what may be best for their case kind of comes into play, where you lay it out for them that, hey, if trying to help you get the most I can for your case. We've discussed that's something you want me to do, and I think that the only way that the insurance company will offer you what you're looking for is by getting the appropriate treatment. And without documentation of that, you're not going to get the settlement that you think you need based on the problems that you're having. So I think that's a big consideration.
Great point. How do you communicate to the claims adjuster you send a lien letter, you tell them I represent these people, and then the claims adjuster is going to monitor. But when do you first tell the defense lawyers or the claim agent, if you're not in suit, let's just say we're not in suit, when and how do you tell the claim rep the severity of your client's injuries?
I try to do that as soon as I can. And I'll tell you, there is a leading organization out there, plaintiffs' lawyers, who say that you should wait to send your letter of representation in, and then you say in your first letter of representation, the human side of your client's story and how badly they're injured and how you want $1 million for, everything. I think that ideally that sounds great, but practically you need to address your client's problems first. And usually when I sign new cases up, the first thing that most people care about is their property damage. And for that reason, I send out a letter of representation pretty immediately whenever I know who the insurance company is, letting them know my client was injured, and then I'll let them know they can call my client directly to discuss resolution of the property damage. But when it comes to figuring out and telling the insurance company how injured my client is, I try to do that as soon as I can. I try to back that up with records.
Okay. So yeah, Steve, that's a great point. I do the same thing. I tell them what's going on, the severity of the injuries, what's going on, and then the adjuster's going to call back every 30 days or so and keep up to speed. So we try to do that, and then ultimately we make a demand letter where we set out exactly what the injuries are. We provide the medical records and any other things. But before we send a demand letter, what I want to do in a case is I want to make sure that we've done everything else that is going to address what the adjuster is going to handle. So if there's prior medical, I want to look at that. If they're contesting liability, I want to take witness statements, or I want to go take a picture of the scene or address that. And then as the client's treating, and I told this story a minute ago, if symptoms aren't resolving or other things, I know a lot about the medicine in these areas, and so do you, and I want to make sure, are they getting the MRI? Do they need an injection? Is physical therapy going to help? Do they need a primary care and a physical therapist, or is it the kind of injury that a chiropractor can well treat? Or what kind of team do you want to set them up with, and how do you navigate that? A lot of people have primary cares and other doctors, but some people don't have those resources. So let's say then the client's done treating and we send a demand letter. Tell me about when you start negotiating, what points do you have about maximizing value in a case?
Well, going back to the communicating the severity of your client's injuries as soon as you can and why that's important, we should talk about anchoring. And there's been a lot of work that's been done on this. There's a Duke behavioral economist named Dan Ariely who has done a lot of studies showing how anchoring usually makes a difference, especially when you're trying to figure out how much something is worth when it's something that's not readily ascertainable. And these personal injury cases are definitely something that falls into that category. It's not a car, it's not a house necessarily. It's something where...
Tell me, I'm going to interrupt you. Anchoring is really important. I always think about it in trial, how to anchor in trial. Honestly, I don't think about it as much in claims negotiation. So tell me what you mean.
I mean that it's the same principle in pre-litigation.
What do you do to anchor an adjuster to a higher value?
Well, that goes to communicating your client's injuries and how it's impacting the life as soon as you can, and try to support that with medical records that show improve your argument. I think the earlier you do this on a case, the higher chance you'll be able to get a settlement done in pre-litigation without filing a lawsuit. And I think that some lawyers are able to get great settlements for their clients without filing a lawsuit because of this, because adjusters are getting new cases in, they're setting their reserves, and if they don't know your case is worth a good amount of money or it is what you want it to be, then they may evaluate it lower, and that may cause problems later on down the line.
So when you're first talking to the adjuster, when you're early on when you're communicating, you want to tell them things like, my client can't hold her grandkid. She can't walk as well. She has a cane. She's having daily pain in this part of her body. She's having headaches. She can't sleep. Those types of things?
Those types of things. Especially,
what else?
My client's having blurred vision problems. My problem's having headaches. She had a low-grade concussion diagnosis in the emergency room, but it's 3 weeks after the accident, and she's still having these problems. She has not gone to a neurologist yet, but I'm trying to let them know, look, these things aren't going away. They're ongoing. You should be evaluating the case early accordingly. They're not going to give you a formal evaluation, but they are setting their reserves.
So you know what I do sometimes? I get too busy. I get these adjusters calling up for updates, and I don't sit and update them. I don't let them know, and then they hear from, it's not that I don't want to, I just say they're still treating, but I don't try to lobby them early on in the case because I'm busy on other things, and my client's going to treat, and then I'm going to get all the records, and I'm going to send them a demand letter. You're saying don't do that. Anchor them in the beginning, feed them the good stuff in the beginning so that in their notes and how they're evaluating the case, you're going to get more value.
That is my opinion. I'm not saying necessarily what you're doing is incorrect. I think
you are a little bit.
I think we have different business models, and that's really what it comes down to, is that I have a business model where I'm the only person working on my cases. I have a lot of touches on each of my clients. I develop relationships with them. Not that you do not. However, you have a lot more of them to service. And due to that, you probably don't necessarily have time, and a lot of other law firms that do personal injury cases don't have time to, try to advance the case early like this.
Does it work?
I think it does. From my experience, I've had great results with it. I'm not trying to tell you it's going to work every time, because there are a lot of facts on cases that make insurance companies fight that you can't change even if you let them know it early. But I think it works on cases where they maybe would be more inclined to set a low evaluation of it from the onset, and you can tell them immediately that they maybe shouldn't be doing that.
So we do it. I mean, I didn't want to overspeak. I say that's my tendency. We keep the people up to price. We send them. A lot of times, what we're doing in the beginning is we're asking what the policy limits are, and then we tell them the medical to justify them telling us this. Mm-hmm. Sometimes when I've been telling adjusters about the nature of injuries, sometimes it works and they respond and they evaluate it high. Sometimes it doesn't. But I think that's a good point of anchoring. What is another thing that we can do to get a better evaluation, more money in the claims stage of the case?
Another thing I suggest doing if you're negotiating a case, if you are frustrated by an adjuster's evaluation after you've already sent the demand, and you want to try to get a settlement done before filing a lawsuit, you can talk to an adjuster's supervisor, but you better have a great reason for doing so. And I say this because I know a lot of people think they shouldn't ever talk to an adjuster's supervisor. It's kind of a almost a whiny thing to do that maybe you don't necessarily get results from. But I have gotten great results from this if you are able to do a few things. And like I said before, you have to have an outstanding reason. So,
what's your reason?
Well, it depends on the case.
Give me one.
But if you have an adjuster who maybe thinks that a client's injuries were pre-existing and they're not going to offer your client a good amount, and you can show them through, let's say they got an MRI that shows significant changes on this accident than before, and there's more symptoms, being numbness and tingling in the hands, for example, that was there post-accident that wasn't there pre-accident. You can show the adjuster's supervisor, look, these things are present, and I don't think that they were.
How do you? What? So you ask. So yeah. Good.
And I think that to do this, you have to be able to have certain skills with the adjuster. You have to keep in mind that these are people too, and you have to understand that they're doing their best to evaluate a lot of cases at once, and sometimes things fall through the cracks. And I think that you can help your client early on by sometimes, having things get rung up the totem pole, but you have to be reasonable. And my point in saying this is you shouldn't just demand a higher amount and make it an astronomical amount just because you think you're being aggressive.
Well, let's move back for a minute, too, and say, look, what you want to do, you don't want to just be aggressive. You don't want to come across as the person who's unreasonably asking for a supervisor. I ask for supervisors sometimes, but I don't know if sometimes that matters. It does and it doesn't. What you want to do, too, though, is you want to make sure that you have a dialogue with the claims adjusters so you know what their hang-ups are. So why aren't they paying the claim? It's degenerative. We think there's prior medical, or we have an issue with liability, or we're not going to pay any medical after 6 weeks, or whatever their reason is. You want to make sure that you get the enumerated reasons why settlement's being bogged down at a low level, and then you say, well, and then and I think what you're saying too is you first try to convince the adjuster about their issues, whether it's degenerative or whether it's liability or what it is, and then if they're not going anywhere, then you say something like, listen, I get we're not going to agree. Can I talk to your supervisor about this, because I don't want to have to go file a lawsuit without giving you guys a fair opportunity to pay what we think is fair in the claim. And you got to be careful, because they are people, and you got to treat them as people. And the other thing is, you don't want to, even if you go file a suit and even if you don't agree, that's still the same people who are deciding whether or not to settle your case. So you can't be too much of a jerk to them, because you can go file a suit and do this, but 6 months down the road, they're still the ones deciding it. And if they decide they want to put your client through hell because you were a jerk to them, that's not serving your client well. So you have to remove your own view or emotion or sense of justice about it, and remember that it's about persuasion. It's not about being right or wrong necessarily.
Persuasion, not aggression. And I think that
that's a good way to say it.
Sometimes personal injury lawyers, we get a little trapped up in thinking we want to be as aggressive as we can for our client, and sometimes that's not the best strategy. Sometimes relating to people and being persuasive is the best strategy.
And that's what I say this to adjusters all the time. I say, listen, I'm going to keep going till I persuade you the wisdom of my position. And I'm not going to argue. You're going to put listen, what's the highest you're going to put on this? Let me do it. And then I try to figure out why. And then I say, and then I try. I don't know. Some of it is What about filing suit to get to a different adjuster and changing the dynamic of the settlement?
That's certainly an option, and that's something that I don't hesitate to do. But I try to exhaust all possibilities in pre-litigation first, especially if it's a case where I know my client wants to get a result earlier than later, and they don't want to have the expense of litigation, because not every client wants to have the expense of litigation.
So what are you? So so you're calling the supervisor and you're telling them what? Are you sending an email and a letter saying, "Here's the medical. Look at page 7 of the ER and look at this MRI report," or what are you doing?
I'm calling them on the phone. I'm sending them, after our conversation, what I want them to look at, but I'm telling them, this is what you need to look at. This is what the adjuster missed, and here's why my evaluation is more in line than what's being offered.
And you find that successful?
I have found that successful in the past, yes.
Good.
I'm not saying these tips work for every case. I'm just saying, in general, my philosophy has been to do these approaches first, and then if they don't work, you file a lawsuit and you go from there.
And you're certainly doing the client the service so that when you file a lawsuit that you have done everything humanly possible, and then you've gone beyond in providing that, right?
That's the somewhat satisfaction you get from this approach.
Right.
I realize it's not, like as I said before, applicable to every case, but there are cases out there that I'm sure if you're listening and you practice personal injury law that you can think of that you have in your files that this would be applicable to.
All right, and then good. Now, not true, all the time in settling a case, it ends up being it ends up being what goes in the client's pocket. And one of the things you do is you push the claims adjuster as much as you can to get them to their highest number, and then you can go to their supervisor, you can provide them new medical, you can say, hey, you need to get a feel for this, this is what my client's really going through, or maybe you need an MRI to show why the symptoms are there, or there's various things you can do on the medical side. But what sometimes people forget is that you're also trying to see what you can put in the client's pocket. So dealing with the liens and handling the liens in the medical is something you want to do while you're negotiating with the claims person. While you're trying to get the claims person up, you're often contacting the lien holders or the providers to talk to them about where their bills are. So that's what we do. And prompting my question to you is, what do you do with liens, and how does that factor into trying to settle them in the claim stage?
Liens are very important. Non-liens are very important for the amount that your client will ultimately receive.
You said non-liens?
Non-liens.
What does a non-lien mean?
Medical bills that did not perfect their lien through the ways under Missouri law that they are supposed to.
Which is most of them, right? Because few people send the certificate, a certified letter, blah, blah, blah.
And not a lot of them, know that you have to send the name and address of the insurance carrier that the lien is against with it. I had a chiropractor I frequently work with tell me that another lawyer was rejecting his lien because he missed a kind of a small detail, but I looked it up in the Missouri law, and there it was. You have to include.
There's a lot of hoops to perfect a lien, and most providers do not do it right.
Yeah. So,
why doesn't that matter?
Well, because you want your client to have a settlement where they have no liabilities that will come out of it.
When you're done with the case, you want to be done. You don't want the chiropractor suing them.
It's very important to me. It's very important, I think, if you're working with other medical providers, you don't, rub anyone the wrong way. But it's somewhat client dependent. I'll say that. That is my goal on all clients, But there are certain clients that want as much of the settlement as you can give them, and they don't care about other bills. And those are somewhat rare instances, but they do happen, where, pay who you have to, but that, that $20,000 there that's owed to the hospital that doesn't have a lien, let them come after me in collections, that's fine. And if that happens, you put it in your settlement agreement that you have with your client, and you don't have to pay it. But what I do on cases, and this applies to more cases where the client maybe just went to the emergency room and then went to the chiropractor, and there's not a ton of damages out there, and there's not a ton of money out there either, is I often treat all medical providers the same, and I often will send checks out where I write full and final payment, whether it be on the lien or the account number, to the medical provider, along with a letter, essentially trying to take advantage of the accord and satisfaction statute that allows them to not come after your client if 90 days passes and they have accepted that check that you sent that says you are offering partial payment essentially as full and final settlement. And I've learned over the years from doing this that medical providers will more often than not accept 50 to 70% of their bill without argument, and it's much easier to get that by sending them a check than it is asking for permission for it on the front.
Ask for forgiveness rather than permission.
Very important, yes.
All right, so
there's some risk to doing this. But
there is risk. So let's unpack a little bit of this. So there's also, I have a whole seminar on liens and how to negotiate, but a couple of things that, so I almost never do I not pay a bill, whether or not it's liened or not. Because what I explain to my client is that the lien is actually with the insurance company. And the insurance company, after they pay, you can send the lien, so the medical lien into the statute goes to the insurance company, right? So you as a lawyer can get a lien notice, but your duty is to your client. And there's interesting ethics issues. In Illinois, there's an ethics opinion that says you cannot stiff a lien holder. There's an ethics opinion on that. And it's a mixed bag in Missouri. So you got to be careful. You just got to be, as you know this, and you already said, I'm very careful. I explain to my client. I try to do this. I think we're on the exact same page here.
Certainly.
But because what happens is the client forgets that they told you don't pay it, and then they get sued later and blah, blah, blah. So
when I mentioned that earlier, I just want to clarify. I was talking more along the lines of non-lien bills.
Right,
case.
a non-lien bill.
That's, yeah, because I never let a client, and I know that the client can tell you to not pay a lien, but you have to hold it in your account until the dispute's over, as far as my understanding. So
right.
That actually hasn't happened to me yet, but
right.
I imagine it will sometime in the future.
So you're talking about a non-lien bill. You're right. You're not obligated. They don't have to. What ends up happening is that, but in the settlement, you may have to promise to protect and indemnify from liens.
Mm-hmm.
What if the insurance company had a lien, but they didn't know it, and you didn't know that they had a lien, and that you settle it, and they say, "Oh, we were wrong. The hospital wants that $20,000 back because they sent us this." So then
I think you're only on the hook if you sent the insurance company a hold harmless letter.
Well, most of the time, in most settlements, they ask you to protect and indemnify from liens. It's standard language in most releases.
Okay.
Now, if they don't put it in, that's fine. But I really try to resolve, whether or not I think the lesson is, whether or not it's a bill or not, whether it's a liened bill or not, you want to pay all bills out of the settlement. Strongly recommend that to your client, regardless of the lien status. I think it is a good practice, too. We use the Missouri lien reduction statute and the Illinois lien reduction statutes to get that. Sometimes if the bills are high and the insurance coverage is low, We do that. We also retain, if we have a dispute with the lien holder, I do that too. I keep the funds in my trust account because a lien holder, they may take a sum down the road that they wouldn't take before. I don't really do the check and the accord and satisfaction trick. You can. It is an accord and satisfaction. If in the memo line you put full in settlement. And I do that sometimes, I guess, if it's a real jerk or it's a low-level amount or something.
Well, here's why it works, in my opinion. You do it after doing the Missouri lien math. So you're playing the pro-rata amount, the half the settlement remaining after attorney's fees. And I have not had many problems.
I've had none if I use the lien. But I don't need to say accord and satisfaction. What I do is I say, under the Missouri lien statute, you get this amount, here's the check, you're done. And then I attach a spreadsheet showing all what we paid to everybody else so the lien holder knows that they were treated just like everybody else.
So I only do that if the amount that I'm paying, I only attach the spreadsheet if the amount I'm asking them to accept is bad. If it's maybe under 50%.
We do it every time we use the Missouri lien statute.
If it's over 50%, they're going to accept it. They're going to accept it.
You're right. They are.
The reality is that medical bills are not paid at 100% by health insurance companies.
Anybody ever.
And they usually get a higher amount on personal injury cases than they do health insurance.
You're right.
So because of that, they're gonna more often than not accept, the amount that you offer them if it's reasonable, and if it is in line with the Missouri lien law. I have, done this where I put the lien holders and non-lien holders essentially in the same basket. I let my client.
I do that all the time. I do the same thing.
And that allows you to have no liabilities go toward your client at the end of the case, which is something that I think all personal injury lawyers should be shooting for.
So great. Well, listen, this has been really informative and I think, you've had a lot of success in getting these cases to settle in a claim stage. We do that too. We got a lot of cases settling in the claim stage, although I will say that I see these cases bogged down sometimes, especially with COVID. I think finally these adjusters are catching up and they're just not offering sometimes. And so the other thing to do to get it to settle, even though it's technically not in the claim stage, we also file suit, get service, do some discovery, and then find the case is settling where we told them it was going to settle before. Because you can go to the supervisor, but many times if you file suit, that goes to another claims adjuster as well. So, and then you've done a little bit more work. You've spent the $250 to file suit. You do a little bit more work, but you're also moving that because not everybody files suits and not everybody, so that can also add value to the case.
There are different strategies that accomplish the same thing, but I think sometimes you can have success doing the supervisor strategy, and it will allow for a quicker resolution. And like I said before, it doesn't always work, but if you have a case where you think it might, I encourage you to try it. Just make sure you have an outstanding reason to do so.
Good. Hey, listen, that's all the time we have for today. Thank you, Steve, for coming and talking with me about this.
Yep.
Would you do another episode with me next week?
Sure thing. Love to.
All right. Everybody, this is Lawyer v. Lawyer with Gary Berger and Steve Gerring. Thank you.